Hi, everyone. If you could take your seats, everyone. Welcome, welcome. Great. As you can see, oh, could we go back to the previous slide, please? I'm the one that did
You've got the power, yeah.
I'm
Hold
the
on,
one that
let's
did
see.
that.
Yep, there we go.
As you can see from that screen, we have much of our Ann Arbor and Ypsilanti and Washtenaw County community collaborating, supporting to make this panel possible. The League of Women Voters Juvenile Justice Group is co-sponsoring this task force forum with all these organizations, and there are many. So we thank you, sponsors. We could not have done this without your collaboration. We thank you from our hearts. Also, a big thank you, especially to the Dispute Resolution Center people, Jillian and Jermaine and now Annika, who have really given us and done so very much. Thanks.
Just leave it to you.
Okay. Here we go. A big thank you also to our presenters and to Jesse, our videographer. To all of you, we thank you. You care. So either you're with us in person or you're with us via Zoom tonight. A bit of history. When Governor Whitmer's task force released their 32 recommendations in July of last year for juvenile justice reform, our team wanted to know and was eager to learn more about these recommendations. Our League of Women Voters group of Washtenaw County Juvenile Justice wants to know how our state of Michigan will create reforms for kids. We want to discover which of the recommendations have been taken up by the legislature this session and which will have a chance. Is this not a fine opportunity for research and data to guide critical decisions on how to improve youth outcomes? Our League of Women Voters Juvenile Justice Group seeks to know how can the citizens of Washtenaw County take this work of the task force to the finish line. So I'm Amelia Jane. I'm privileged to be a part of the Juvenile Justice Group of the League of Women Voters, Washtenaw County. The League of Women Voters is a nonpartisan voter education organization encouraging informed, active participation in government. While the League does not support candidates nor parties, we do take positions on issues we have studied. Our programs will not necessarily represent these positions, but provide forums to increase understanding of public policy issues. Before I pass the mic to our moderator, Susan Randall, I'd like you to know a little bit more about her. She's an activist for youth justice. She's an advocate for kids, especially if those kids might get their needs met without entering the justice system. A couple of years ago, Susan moved here from South Dakota. There, Susan's work at the Voices for Children organization focused on reform in that state's harsh juvenile justice system. Primarily at Voices for Children, she helped and worked to raise South Dakota's compliance of juvenile justice practices with those in the rest of our country. Susan Randall became part of the Juvenile Detention Alternatives Initiative, a national alternatives initiative. So, how perfect for us in our League of Women Voters group that Susan Randall has chosen to prep for several months to bring this discovery evening together. She will moderate our forum, so it's time. And again, I thank you, all of you, and those on Zoom for attending. I want to thank our presenters. Thank you, Susan, for moderating, Jason, Kimberly, everyone.
So welcome to all of you. I join Amelia Jane in gratitude that you're here tonight. Last May, I had the opportunity to hear Supreme Court Justice Elizabeth Clement speak about the Task Force on Juvenile Justice Reform, which had been appointed by Governor Whitmer and was going to examine our state's juvenile justice system. She said the report was going to be released in July and that it would be an important roadmap for change. So I knew from my own experience over 10 years working on juvenile justice reform in South Dakota that when you bring stakeholders from all of the disparate aspects of a juvenile justice system together, a system that often is rather loosely connected, that is a feat of accomplishment in itself. And then when I learned that the National Council of State Governments Justice Center was being brought in to do an independent assessment of Michigan's juvenile justice system and essentially hold up a mirror to the task force of how the system looks and operates, that was feat number 2. And so when the report was released in July with 32 recommendations, it was clear that we really needed to pay attention to the recommendations, and the idea of holding this forum, expanding the awareness of citizens in our county about the forum came about. And I think the fact that we have 10 groups in Washtenaw County that have co-sponsored this forum is testament to the interest that exists in the recommendations for reform and the desire to see change come. Our presenters this evening are 2 highly qualified and actively engaged members of that task force, and I might add that we're fortunate that they are also residents of Washtenaw County. So what a boon for us. Kimberly Thomas is a professor at the University of Michigan Law School. She has been in that post since 2003, and she co-founded at the university the Juvenile Justice Clinic. In 2013, Kimberly, with other attorneys, received the Justice for All Award. It was from the Criminal Defense Attorneys of Michigan, and it was for work she did with others in training and pro bono support following the U.S. Supreme Court decision in 2012 that declared mandatory juvenile life without parole sentences unconstitutional. She's a graduate of the University of Maryland and of the Harvard Law School, where she was editor-in-chief of the Civil Liberties Lawsuit, or Law Review, excuse me. Jason Smith is our other presenter tonight. He's the executive director of the Michigan Center for Youth Justice, where prior to becoming executive director, he served as the director of youth policy. Earlier in Jason's career, an interesting range of experiences. He was a direct care provider at a transitional home for adjudicated girls. He also served as a case manager of the Wayne County Juvenile Justice System. He has been a co-manager of a youth diversion program in Skokie, Illinois. And in 2011, he was a fellow with the Youth Justice Leadership Institute at the National Juvenile Justice Network. He is an MSU graduate and has a master's in social work from the University of Michigan. So Jason and Kimberly, we're really glad that you're here with us. I'll say welcome, but before I have you join the mic, come to the mic, I'm going to mention a couple of things about our protocol for tonight. So we ask you to hold your questions until our presenters have completed their overview of the task force. And then we've reserved the final segment of our forum tonight for a question and answer with you, our audience. The protocol will go like this. There will be a microphone towards the back in the center aisle here. Carolyn Madden, raise your hand. Carolyn will be the mic manager. If you may ask the question that you have, they can come to us from one of 3 ways. You can physically get up and walk over to the mic manager and state your question yourself. If you prefer not to do that, there are papers on your tables. You can write your question out and pass it to the center aisle, and they'll be collected and asked by the mic manager. And those of you that are on Zoom can submit your questions on the chat. And Jesse, our videographer, will bring those to our attention. Okay, having said that, let's get rolling. And Kimberly and Jason, it's in your court.
Thank you so much, Susan. We got advanced to the presentation already, so let's get going. I'm going to cover a little bit of the overview of the task force process and then what we learned, both through the research that the Council for State Governments did and through the rest of the task force process. And then Jason's going to take us through the recommendations and the next steps. And so that's our plan. But first I wanted to start with a slide that shows some of the issues that have been raised in our youth justice system. And this is really from the last 5 years. This is not a long, ancient history. But we had the National Juvenile Defender Center came and did a report on the provision of youth defense services, which was called Overdue for Justice. So you can sort of get a sense of how that came out. We had Grace, who was detained for not doing her online homework out of Michigan County. Cornelius Frederick, who was a young teen who was killed at a detention facility. There was a report on the use of fines and fees in Michigan and how they burden the young people that are involved in our youth justice system. And I'm sure if you're in this audience, you're probably aware of some of the concerns around the detention facility in Wayne County that are ongoing as we speak. And so there are a lot of issues for us to think about. And what the governor did was create, through executive order, the State Juvenile Justice Task Force. Our job was to create and look at a data-driven analysis of our youth justice system and recommend practices for change, for deep strategic change that were grounded in data and research and best practices in youth justice. The membership of the commission was broad. It included people from all 3 branches of government. It was chaired by Lieutenant Governor Garland Gilchrist and included also people, advocates such as ourselves, people that were directly impacted or involved in the youth justice system, people from law enforcement, people from education, DHHS. So there's a really broad range of stakeholders that were at the table. And a lot of the recommendations are unanimous. And so that was a really nice thing to be able to achieve, that kind of consensus with people that are really coming from different places on these issues. The partner, as was mentioned, was the Council of State Governments. They're a nonpartisan group, and so they're not coming in with a particular agenda other than using data and evidence, using best practices, and really trying to help us improve our system and understand what are flaws in our system. There were also a series of working groups that looked at specific issues, and so some of those were the court process, data, diversion, juvenile defense, financing, out-of-home placement. And so you can see that there were subgroups of the commission that took a deeper dive to have a really more nuanced both understanding of our system, but also we were able to hear from other states to hear about what other states were doing that we might sort of uplift some of the practices that we're engaged with. And so those were really great conversations to be able to have. One thing that you'll probably hear more than once tonight, but just to notice, data is an enormous problem. So we actually don't know how many kids are in detention right this minute. That is not a fact that is known in the world. We don't know who those kids are, we don't know where they are, and we don't know how many of them there are. And so we have really fundamental data gaps that lead to fundamental gaps in our ability to provide and care for young people in our state. And so the Council of State Governments took really the most comprehensive look at the data that they could. So they were able to get data from 32 different counties. There's this case level data for 4 years. That data represents about 55% of the young people in our state. And so while it's not a statistically, they couldn't choose which counties they got data from, those counties represented both urban and rural counties. So it's a broad range across the state. And so it gives us a pretty good snapshot and quantitative data on what our system looks like. They also did literally over 100 focus groups of different interviews, people who had gone through the youth justice system, families, tribal groups. They really, really wanted to understand how people experienced the current system and what the flaws they saw in it were, and what the practices that were working really well were. And so they could both shine a light on those good practices, but also understand what our flaws were. What did we learn? Well, we learned, maybe unsurprising to some of you, that we really lack some fundamental statewide structures. And so this first slide is on diversion. So what did we learn about diversion? Research shows that low-risk young people do, if they are processed through the court system, are more likely to recidivate, right? So there's really good data on that. If you take a low-risk kid and you formally process them through the juvenile system, there are worse outcomes for that kid than if you diverted them, even if you divert them and provide no services whatsoever. And so what we saw is that for diversion, Michigan really lacks a coherent framework for diversion. There are diversion systems. They are used differently in different counties. There's not a lot of coherence to what is implemented in diversion. And we also saw that the formal system is heavily used for those low-risk kids. And so those low-risk kids are ending up in our formal court system. So for example, this graphic, about half of all petitions were for status offenses or non-person misdemeanor offenses, which are typically the kinds of offenses we might think would be diverted out of the system. We also learned a little bit about probation practices and fines and costs. There isn't our probation practices are not aligned with research. There's no risk and needs assessments to know what kids' needs are. There isn't consistent mental health screening. There isn't consistent understanding of what might be appropriate services for any particular child that is applied across the board. In terms of fines and fees, what we learned was that there are some mandatory fees, but most of the fees are discretionary. And some counties have chosen to completely waive those fines and fees, and so we heard some success stories about the impact of that. And some counties still routinely impose those fines and fees, even on families that are indigent, that can't afford to pay those, and they just apply them consistently. A third area we learned more about was indigent defense. We learned that there isn't really structures or minimal standards, supports or resources at the state level for indigent defense. And here's one place where that qualitative data really shone through. The young people and families that were interviewed reported that they thought their attorneys weren't prepared, and they had very little interaction with their counsel. They really didn't see that person as an ally for them through the system that they were going through. The next slide is on pretrial detention. So pretrial detention is if someone is arrested and they're going to go through the court process, but there's a question about whether they stay at home in the community or they're detained in a youth detention center. And our laws look to the risk of flight as a relevant criteria for detention, as well as the public safety. And what we learned was that detention was not just used for people who were at risk of flight or that were a risk of public safety, but it was used for behavioral issues. It was used for lots of other purposes that weren't either statutorily mandated or what was really set up for. We also learned that there was enormous variations across counties. So some counties, pretrial detention was 6 to 23 per 10,000, and some counties was 10 times more. So 138 to 228 youth per 10,000. So there was this dramatic range of practices across the state in terms of kids that were held in custody. This is a slide relevant to post-disposition placement. So if a child is found responsible or admits responsibility, there's a hearing that, if you're familiar with adult criminal system, would be a sentencing hearing, but in juvenile courts called a disposition. And so then the question is, as a disposition, what happens to that young person? What are the support services or treatment options for them? And there was some pretty interesting data on people who were taken out of their home post-disposition. We learned that there weren't consistent risk assessments, there weren't health screenings, there was no minimum age for people who were placed in placement outside of their home, and there was no guidelines for the length of the stay. There were not funding incentives to keep kids in the community. In fact, the funding incentives sort of worked the other way. They sort of didn't encourage community placement even when that was the right choice, but sort of discouraged that through some funding incentives. And that, the graphic is state supervised kids who did have dispositional assessments. It showed that the majority of kids were low or moderate risk to reoffend, but they were still placed outside of their home and outside of their community. This is, again, on disposition. And so really looking at the services that are provided, there wasn't a consistent level of services with regard to things that you might hope, such as educational placement, mental health treatment in facilities, engagement with families, and sort of creating that reentry back into the community for kids who were taken out of the community with their placement. Yes, so the residential system, I think that, you sort of see the Wayne County example, but we know that there's some structural problems. The problems with placement were really exacerbated or sort of shined a light on by COVID, by staffing shortages, by DHHS relicence, and so they have gotten sort of worse over time really recently rather than better, and there's a real, I'd say this is the one that's probably closest to a crisis at this point. We also learned that our system is not racially proportionate, that especially Black youth are overrepresented in the young people in our system. Black youth are petitioned. Petitioned is when the court, there's a request to charge them at twice the rate of white youth, and they're 1.5 times more likely to be adjudicated. That's the finding of responsibility. Black youth spend more time in detention than white youth. And there's another slide. So here's a relative detention rate, and the sort of dotted line down the middle is white youth. And here you see that Black youth, I think, is 6 times likely to be detained as white youth, and they are 3 times more likely to be placed in a placement outside of their home. And so the burden of our system and the inequities we saw in our system did not fall equally upon all children and fell disproportionately on Black children in our state. So our big picture is we don't really have sort of a statewide safety net of quality assurance or best practices that counties can look to. The state hasn't, sort of make the county's job easier to do the right thing. And that we don't have data to answer really fundamental questions about what our system is and what it looks like. And so I'm going to turn it over. You get to be like a little more sunshine to my rain, I think,
So good evening, everybody, and potential sunshine, I'll say that I am. So again, Jason Smith from the Michigan Center for Youth Justice. So that entire process, going through getting a baseline understanding of how the juvenile justice system works, looking at statewide data, having conversations with multiple stakeholders within the system and those who were impacted by it, those who advocate for change, and being on the work group. Both Kim and I were on several work groups. We ultimately, the task force developed 32 recommendations that were placed into like 6 broad categories. And you can see by the list that they kind of align with the working groups that Kim highlighted before, not completely. And you'll see that some of the recommendations, they kind of overlap, or they could have really fit within several of these buckets, and that's just how they were ultimately laid out in the final report. So I'm going to highlight all 32. through with these 6 buckets, but know that if you look at the actual report, each of these recommendations have several sub-points or sub-recommendations underneath it, and I kind of highlighted the ones that I thought folks would find either interesting or that are the most pressing or relevant. So, all right, whoops, did I skip one? So, the first recommendation is focused around system structures, overall changes to the statewide juvenile justice system, and aligning funding priorities to ensure that they align with where the direction that the system is heading into. So, an example of that is enhancing the child care fund. So for those who don't know, the child care fund is the primary funding source for the juvenile justice system. It's a reimbursement model. So the local jurisdictions, the counties, pay for all of the costs up front, whether it's community-based care or out-of-home placement or detention, and the state reimburses the county back 50% on the dollar, and that's for both, for in-home care and out-of-home care. And so the goal of this recommendation is to use the child care fund in a way that supports more statewide standards and practice around the state, incentivizes community-based care, and I'll dive into it when we get into the potential legislation for this year. And then also ensure that courts and counties are using programs and services that are evidence-based that can yield good outcomes for kids. The second structural recommendation or system structure recommendation is to establish a juvenile justice service division within the State Court Administrative Office, or SCAO. So this division would support the local jurisdictions in providing technical assistance as they implement these various recommendations over time. We'll analyze data, collect and analyze data on current programs and services and new ones that are being explored for implementation. But then also working with local jurisdictions to make sure that standards and practices across the board, whether it's court processing or probation standards, that we can have as many uniform practices as possible. And then Kimberly highlighted the need for better juvenile defense around the state. So there's a recommendation to expand the Michigan Indigent Defense Commission to include oversight and development and compliance of youth defense standards, either by expanding the current indigent defense standards that support the adult system and defense in the criminal justice system or including new ones so that youth defense is covered. And also provides increased training for youth defenders, and also resources for the State Appellate Defender's Office so that they can handle appeal cases and any kind of cases that happen, or issues or hearings that occur post-disposition. Okay, so additional structure change recommendations, establish a statewide residential advisory committee. As Kim highlighted, there's some major issues happening right now around the state regarding the use of residential treatment, access to residential treatment for kids, and also detention. The goal of this, similar to the task force, it would be comprised of multiple stakeholders, court professionals, folks representing the state and DHHS, tribal representatives, advocates, prosecutors, defense attorneys, folks who were directly impacted, to really have a broad discussion on what the use of out-of-home placement in our state looks like. How many beds do we actually need? What kids, who actually would benefit from out-of-home placement, and for whom really the need is for the expansion of community-based care or alternatives, and what does that look like? How does funding of residential placement beds look like? What type of treatment beds do we actually need? Do we need more specialized care? Are there opportunities for looking at alternative, even out-of-home placements, like specialized foster care for kids in the juvenile justice system, or emergency shelters for kids who may have an issue at home but just needs a short-term respite or situation, but not necessarily longer-term residential care? We're hopeful that once this residential advisory committee is established, and I think it'll be done by appointment by the governor, that a lot of these issues around out-of-home placement will be looked at deeply. Establishing cross-system, cross-government regional service committees, really focusing at the local level on supporting the courts and counties and coordinating child care fund dollars to ensure that it is going towards a robust continuum of care in communities, and so that kids have access to the right programs at home with the right dosage, et cetera. Expanding, is this a new, this is a new category, diversion, and I was on the diversion work group, and I'll tell you that those were some intense but good conversations, because you're talking about simply what child would benefit from non-formal interventions. What kid needs to be in the legal system, who can be served and have their issues addressed, be held accountable, repair harm, et cetera, without legal system involvement. So the recommendation coming out of that work group, informed by the other conversations that were a part of the task force and then ultimately voted on by the task force as a whole, was to expand the Michigan Diversion Act, which is the statute that really dictates what diversion looks like in the state, so that all offenses, except for the most serious ones, and I think diving more into that, that's really looking at the offenses that are eligible for waiver to the adult system, so your most serious offenses in that case. But outside of those are eligible for pre-court diversion, and based on the use of a risk assessment tool. So the goal here is to ensure that kids are eligible for diversion based on their risk, their risk versus their offense solely. And then also align pre-court diversion and consent calendar, which consent calendar is essentially like an informal docket that kids can be placed on instead of going through the formal adjudication route. Align pre-court diversion and consent calendar conditions with research and developmental science. One of the things that we also know is that, and Kim highlighted it, and the report does as well, that there's variances even in what diversion looks like, what kids are offered, the length of time that they have to be on a diversion program. And so the goal here is to try to create more standards in practice. Additional pieces that came out of the diversion work group: establishing a minimum age of juvenile court jurisdiction. This one was a bit more contentious, and that one was not a uniform vote, right? Yeah, that was one of the few that was not uniform. But still, the majority voted to establish a 13 as the minimum age of juvenile court jurisdiction. And then for status offenses, which again are offenses that are solely offenses based on a young person's status as a youth. So think school truancy, running away from home, incorrigibility, which essentially is not like obeying the rules of your family's home. Referring those young people who have been alleged to commit a status offense to get a risk assessment and participate in diversion as much as possible. Court processing, again, this is the work group in the category that's focused on the system and how the court process engages with youth and families and how they engage with it. One of the recommendations is to eliminate most non-restitution fees and costs. So this is something that's the Michigan Center for Youth Justice has long been an advocate for. Kim highlighted that there's been reports and news stories about the impact that juvenile court fees can have, and I've personally heard very strong and tough stories about families that are struggling to make ends meet and pay back the debt to the juvenile court. So the goal there is to eliminate most fees. And without, I think restitution would still remain, and the Victim Rights Fund that goes to the state. Require a validated risk and needs assessment to be conducted for all youth prior to disposition. Again, making the system more data-driven, informed by validated risk and needs assessment tools for decision-making. Additional court processing recommendations, scale with proper funding in partnership with the local probation departments and other stakeholders to establish statewide research-based juvenile-specific probation standards and guidelines. So looking at, again, things like length of time on probation, what probation interactions look like, when the decision is made to violate a young person's probation, and in what situations you would do that. Re-examining juvenile waivers. So this is the process that can potentially lead to a young person being transferred to the adult system. So the recommendation is to create a statewide study committee on juvenile waivers to review data on the use of waivers and designations, which is another process of transferring youth to the adult system, and examining national best practices, and then developing a final report with recommendations, and then looking at the factors considered by the court for traditional waivers, and that it should account for a young person's developmental maturity, emotional and mental health, and their ability to get more treatment and rehabilitation for their needs in the juvenile court. So really looking at beyond just their history of interactions with the justice system or the seriousness of their offense, to really take the totality of that young person's situation in determining whether or not waiver to the adult system is the right course of action. For the out-of-home placement category, a couple that I want to highlight, again, was related to screening, risk risk assessments and screening tools, requiring a statewide detention screening tool to be used prior to detention decisions as a way to help guide placement decisions and establish clear authority for what entities can make that decision around detention. And again, this is one of the things that new scale division would support the local jurisdictions in implementing these risk assessments and screening tools. And there was a recommendation to restrict the use of detention, pre-adjudication, so before a young person has been found guilty, for anything, for non-public safety reasons. If they are not a risk to themselves or to others, they should be at home. And then also limiting detention for violations of court orders for status offenses. So right now, under Michigan statute, courts cannot detain or place a kid in detention for the adjudication of their status offense alone, but they can place them for violating a court order after they've already been adjudicated for a status offense, if that makes sense. But still, as Kim highlighted, the research shows that detention often and out-of-home placement can actually make outcomes worse for kids for whom, like, their only offense is a low-risk misdemeanor or a status offense. And so the aim here is, again, to, as much as possible, when a young person's needs can be addressed at home, in the community, with their family, at home, continuing going to the same school they go to, that should be the ideal. That should be the priority. And residential placement and detention should only be utilized after all other options have been exhausted. More on the out-of-home placement recommendations, improving out-of-home placement standards by improving and updating the licensing and service standards that the state manages and uses to oversee and monitor facilities, and this goes for both residential facilities and detention facilities, and develop a case review process for youth in detention over 30 to 60 days and private and state residential facilities over 9 to 12 months to look at whether or not it can be feasible to place them instead in community-based alternatives and reduce their length of stay. Ultimately, the issues that we're currently seeing in the residential treatment facilities and detention can only be, resolved if there's fewer kids in facilities. Strengthening facility services and oversight by creating standards for all state and privately run juvenile justice residential facilities, and regardless of the facility or a child's wardship. Here in Michigan, you can either be a temporary court ward or a ward of the state, and often they're placed in the same facilities. and sometimes oversight it looks a little different depending on your wardship. But the goal is to make sure that no matter where you're situated in the system, where you came from, and what type of program you're in, that you're placed under the same safety and oversight and standards, no matter where it is around the state. And then expanding the Office of the Children's Ombudsman to investigate incidents in all licensed facilities. Right now, their main focus has been primarily in the child welfare system, but expanding their oversight to juvenile justice facilities as well. To the point around data, and it has been a long-term bugaboo for many of us who are passionate about juvenile justice issues. The recommendation is that the State Court Administrative Office should develop data standardization protocols for collecting and sharing data by local courts so that it can be used to inform decision-making, both at the local level, I would say, and then also at the state level, whether it's state departments or legislators looking at juvenile justice policies to drive system improvement. So things like making sure that everyone's using standard definitions in data entry, or well, essentially that everyone's entering the same level of data so that we can do comparisons across the state and really be talking apples to apples is the goal there. And then establish robust quality assurance procedures to assess and address data quality issues and ensure that there's data integrity so that there's no doubts about the accuracy of the data statewide, and that we're seeing that trends and things like that can be analyzed over time. And then the final category, I believe this is the recommendations around ensuring that the system is fair and equitable and includes and uplifts the voice of young people who are directly impacted by justice system involvement in their families. I want to commend the Council for State Governments because they really did a good job, and it's difficult, to without really being intentional, to include people who are directly impacted, especially young people and their families. And I think that they did a really good job not only having young people and family members on the actual task force, but throughout the work groups, but also doing specific focus groups with people who were directly impacted by the system and inviting various task force members to participate. And those focus groups were awesome. Those families knew what their role was, and so they highlighted the good and the bad, and it really informed these conversations and really shows why it's important that those who are directly impacted, they know the solutions, and they're experts in their situation too, and should be listened to and help inform policy discussions. So one of the recommendations was to establish statewide definitions and protocols for capturing data around race, ethnicity, tribal data across data systems. The only way that you can be intentional about addressing, for example, racial disparities if you're actually tracking that data over time and really looking at it. So the goal there is to establish a baseline and track progress on key measures for statewide disparities. And then establishing a statewide youth and family juvenile justice advisory group to inform resource decisions and policy implementation, making sure that, again, those who are directly impacted by system involvement have an opportunity to vet, provide feedback or amendments to policy recommendations. And so where we currently sit in the beginning of a new year and the beginning of a new legislative session is that the goal from those who have kind of been tasked with working on advancing some of these recommendations into actual implementation is to focus on core reforms that are foundational, like a lot of the structural things, for example, but are ultimately transformational reforms. And the hope here is by focusing on things that are where there's the most consensus, where they can build structural changes, you can continue to build upon that by working on more progressive reforms over time. So there's 6 legislative priorities currently that are being discussed in the legislature, And then there are 3 of those recommendations that can be implemented without statute. They all, to a certain extent, well, not all of them. There will be some need for additional funding and appropriations for them, but 3 of them can be implemented by court or administrative policy changes. Those 3 are establishing the JJ division within scale, establishing the statewide residential advisory committee, which I believe will be appointed by the governor, and then establishing the statewide youth and family justice advisory group, which I believe that DHHS is managing that process, and they've already sent out asks, which I'm happy to send to Susan and Amelia that document, what they're looking for young people to participate. So current legislative priorities, number 1, the one that has the strongest consensus, I'll say, somebody may disagree, but what I hear, is enhancing the child care fund by establishing a minimum framework for juvenile justice practices statewide. So the main focus here, remember I said that the way that the process works is the counties pay up front 100%, county reimburses back 50%. Increase the reimbursement to the local jurisdictions to 75% for community-based care. So detention and out-of-home placement would stay at 50%, but increasing the community-based service reimbursement to 75%. The goal there, of course, to incentivize the use of more community-based care. Better outcomes for kids, is more cost-effective for the courts and counties to implement, but also more cost-effective for the state to reimburse. So it's a win-win. As an advocate, we want to see more kids at home, but a lot of the justice stakeholders really pushed for this change too. Then also, as a part of that, requiring that piece around the use of risk assessments and screening tools to drive decision-making, to make sure, again, that funds are used the most appropriately, that kids are placed in the right programs for their needs. Whoop, skipped one. Second is creating the statewide juvenile defense structure, so expanding the indigent defense standards to include youth defense at local county defense systems, and also bringing on some indigent defense commissioners that have experience with the youth justice system or juvenile justice system, and expanding SADO, the State Appellate Defender's Office, to provide services for kids. Again, expanding the Diversion Act is one of the priorities that are currently being looked at this year. That piece around expanding diversion to all offenses, save for those specified juvenile offenses that are eligible for waiver, and then limiting the length of time that a young person can be placed on pre-court diversion. There's legislation being discussed and will likely be introduced around revising the factors that are considered for the use of traditional waiver, again, to better account for a young person's maturity and their ability to get services in the juvenile justice system. Again, looking at factors beyond just what they did or their record. And then eliminating fines and fees, again, save for restitution and the Victim Rights Fund. But then also for any fees that remain, creating a more standard procedure to look at ability to pay. Strengthening and expanding the Office of the Children Ombudsman for handling, investigating, and reporting incidents in juvenile justice facilities, as well as what they currently do in the child welfare system. So, how you can help. We're currently in the legislative process. The hope is that we will see a bipartisan bill package or number of bills related to these task force recommendations introduced fairly soon. What I hear is that it'll likely be both in the House and Senate. If you want to be updated on the process, we include information about the task force recommendations in our monthly newsletter, so please feel free to sign up. The sign-on letter, sign-on sheet that everyone signed at the beginning, I believe that The goal there, oh, they haven't signed it yet? Sorry.
Yeah, we'll be circulating a sign-up sheet in a minute.
Got ahead of the game.
Yeah.
We'll add you to the newsletter so that you can get those updates. And we only do it once a month, so you won't get inundated with too many emails. But then also, as you find out about bills being introduced, and you don't necessarily need to wait for it, but bill numbers always help when a legislation's been actually introduced. Call and email your state legislator and ask them to support the Juvenile Justice Task Force related legislation. Additional ways that you can help is hosting events like this. You know, like what I love to do is get out in communities and help educate the public on issues related to juvenile justice and how they're being discussed around the state. So if you're not from Washtenaw here or watching on Zoom, host a similar event like this to spread the word on the task force's work and recommendations. And then also I encourage you to engage your court stakeholders, be it prosecutors, judges, defense attorneys, about how the local juvenile justice system works and how they plan to implement the task force's recommendations. And that is it. Thank you.
Right, thank you. Okay, while that's going on, it's your turn to ask questions. And just to review our protocol, if you prefer to write your question, you can write it here and pass it down to the center aisle. Carolyn Madden will be our mic manager. I'll be giving her the mic in a moment, and you can feel free to walk up to the mic and pose your question directly. And if you're on Zoom, please add your question in chat, and Jesse will see to it that it gets posed. So while we're waiting for more questions to come, I'm going to start with one that was submitted ahead of time. So a theme in the recommendations is requiring validated risk screening tools and validated needs assessment tools at every decision point in the protocol, like diversion, the detention decision, the post-disposition decisions. The question is this: where do these tools come from? Who does the validation, and how does staff, or do they need to be trained in order to administer those tools?
Microphone.
And you'll have to use the mic here since we're limited to two that are working.
Yeah, no problem.
All right.
Hi again. So there's various tools that courts who currently use them utilize, and they come from private vendors. For the most part, there's some that have been developed by universities. And again, they can assess young people at various contact points within the system, whether it's diversion, arrest, or the use of out-of-home placement, or even reentry, like I've seen risk assessments be used for. Typically, there is some training that's involved, and you know, I'm not the expert on implementation of risk assessment, so I don't know if it's actually the provider who does the trainer, or there's some sort of train-the-trainer model. I imagine it varies across the system. But what we do know is that it's not uniform that everyone uses one, whether they use a standard risk assessment at a certain contact point or not, that the use of risk assessments, or even if there is use of it, fidelity to what it says, or really responding to the results and informed decision-making can really vary across the board. So the goal here, again, is to place standards and make it a standard practice that you use risk assessments to drive case planning.
Okay. Say your name first.
My name is Dwight Wilson. In talking about the data, you said that there is a look at the ratio. First, I should say, I want to thank you all for the work that you're doing. Yes. It's the only way that we can actually arrive at justice is to try to get rid of some of the oppression that is in this society. But in talking about the data, you talked about racial, ethnicity, and tribal data. But we, in this country, skirt around the problem of class, of social class. This is a curse word. Perhaps if we looked at the level of education of the parents that would also give us a deeper idea of who is being put into this system. Is there anything that is moving in that direction?
So thank you for your question. I don't think there is anything that the task force looked at that's looking at parental education per se as a marker. So I guess maybe a couple things. One, there definitely was attention to, and I think importantly, to the young people who are indigent and come from families who are low income, and their experience of the system. And so the attention to indigent defense, a child, just because they're from a low-income family, shouldn't have a different experience of their lawyer than a child who their family can afford a lawyer. The impact of fines and fees on a family. And so so that's one way in which I think the task force wanted to think about what the experience of the court system looks like for low-income children and their families. I do think that some of the risk assessment tools look at the child within their family, and so they might take that into account. But that's really, I'm not going to, I think that varies across tools, and so but isn't it something the task force specifically looked at? Did you have anything to add, Jason? Yeah. Yeah.
My concern was really who's getting charged. That's what it was.
I want to add, too, that, and back to the how you can help session, like, there's opportunities for us to inform what juvenile justice data in the state looks like, both locally, I would say, and what local courts collect, because, there may be a situation where there's standards of data collection across the board, but there will be courts who are interested, in communities who are interested in collecting beyond what the standards are. And so there's opportunities for us, especially as these conversations are just beginning at the statewide level around juvenile justice data, to really inform what that looks like. Can't say that everything will be included, but we have the opportunity to really inform, like, what the statewide we're looking at in relation to young people who come in contact with the system.
All right, we have a question from online from Lawrence Root. When looking at the variety of county-level provisions related to justice-impacted juveniles, can you talk about how local economic resources as well as perspectives on the severity of offenses may be associated with how juveniles are treated?
I don't think we know which communities were which.
Yeah.
So one answer to that question is that the data that the Council of State Governments got from those counties, those counties weren't identified, right? So we can't, the data doesn't tell us, I guess, what, were the rates of incarceration higher in a particular county that has this particular socioeconomic characteristic. Some of the information we received did not suggest that it was based on, for example, rural versus urban or location in the state, that it was more heterogeneous than that. And so we didn't see, just rural counties doing a particular thing or just urban counties. It wasn't divided along those lines in a way that was predictable. And so it seems a little bit different than that in terms of where the decisions were being made.
Okay, a question from the audience. Who, when, how often will fidelity checks or accountability checks be done on all the transformational changes?
Yeah, I mean, I think that that's something that we'll all be responsible for in the legislature too. But I'm also hoping that scale division, that is a process of their work, is to regularly be looking at statewide data and local jurisdiction data too, to support, lift up the good practices that are happening, but then also support jurisdictions in improving where those are needed. So again, it's going to take all of us, but I'm hoping that that is one of their charges and one of the recommendations of the task force, that scale division takes on a large brunt of data analysis and making sure that folks are fidelity, or doing their models to fidelity.
Yes, Rod Casey, Ypsilanti Township Democratic Delegate, and also activist, social, and justice action advocate. We had a law that once a kid, once upon a time used to be, once they got 18, their records were sealed. And the last time I checked, this was shown that it was, a child record wasn't sealed until after he was 30 years old. Is that still in existence?
Shout out to Senator Irwin.
Yeah. So Senator Irwin, who's here, supported legislation in the previous session that would improve juvenile record confidentiality. So there was 2 bills that were placed in the statute. One that made all juvenile records non-public, but then also, similar to the discussion and the work that's been done on the adult side, create a process so that the majority of young people, that their offenses were automatically sealed. So there wasn't anything that they had to do, any work to make that happen. For some youth who have serious offenses, they would still have the opportunity, and even that, in the statute changed and improved, to go and apply to have their records sealed. So
I mean, even like for auto theft, which mostly every
yeah,
kid
I
do.
believe that that's an I don't have the offense list in front of me, but like similar to that diversion list where I said that it's really limited to the specified offenses that you can be waived to the adult system for. It's a little bit more expanded than that, but by and large, the majority of offenses that kids commit here in Michigan and are placed in the juvenile justice system for would be eligible for automatic record sealing.
Oh, thank you. I just wanted to ask you before Jeff left you.
Kudos to him.
Thank you. We have a couple questions from online, talked about asking about any sort of local resources for training. One was asking about training that is available, like Know Your Rights training for teens, and we also have a K-12 educator who is warning about training resources that might be available to them regarding these topics.
Locally, I don't know.
I don't think I have it. So I think most of those resources, training on the task force recommendations haven't happened yet. I guess, Jason and I are here tonight, so we're starting. But I think that there isn't the robust kind of training either for young people or for educators that there hopefully will be. Just to say to the K-12 educator, the task force recommendations are really bookended by the juvenile court system. And so there is a lot that was unstudied and unsaid about, for example, education of young people who might lead into the court system or who are court involved. And so there's a lot, that whole topic wasn't even in some ways on the table, right? And so you'll notice, now that you've heard all the recommendations, there aren't recommendations about education. And so, just to sort of uplift the work that there is left to do, you may have a more,
Yeah, no. I mean, that was an important point to make, and something that I highlighted during the process. Even when talking about diversion, we unfortunately were narrowed to a specific point for diversion and not school-based diversion and things like that. So I think, even beyond the task force, and as folks know, and Senator Irwin is sponsoring legislation for issues that weren't even covered in the Juvenile Justice Task Force that are related to juvenile justice, like life without parole and things like that. There has to be continued discussions around the systems that engage with young people before they're in the juvenile justice system, and really look at root cause work beyond these recommendations that really focused on kids after they come in contact with the court, And so we support these, of course, and that's what we're here to talk about, is the Juvenile Justice Task Force recommendations. But ultimately, we need to also be looking at the issues that drive kids into the legal system. And for sure, really build up those alternatives so that kids are never involved with the legal system simply to receive services. There has to be the what. And creating the what, if I can go on a rant for a second, creating the alternatives or the what kids would be placed in instead of the juvenile justice system, it will make going beyond these 6 core things that we're focused on now, these foundational changes, it'll make advocating for a minimum age, advocating for reforms around status offenses to completely move them out of the system that much easier if you focus on those root causes and create alternatives. The what else those kids would be referred to.
Okay, we have a lot of people lined up here
Right.
from the audience. Are out-of-home placements private or public? If private, does this make it harder to get data regarding it?
The majority of youth that are placed in residential placement, so when you're talking about residential treatment, those are your longer-term facilities, right? Detention, like the one here in Washtenaw County are similar to jail, really meant for short-term stays. It's just because of issues now, kids are staying in detention a lot longer than they should. The majority of kids are placed in private residential facilities. There are only 2 state-managed facilities in Michigan. Both are in northern Michigan, one in, I want to say Gaylord, and then the other one is in the UP in Shawano. But again, majority of kids are in private. And yes, I would say that it does make it more difficult to access data. It's hard to, again, not only know how many kids are in a facility at any given time and for what, but even outcome data, like what was the recidivism rate for kids who participated in a particular program? How did it help or how didn't it help? It's really difficult to know that. And it's one of the things that we hope that the Residential Advisory Committee, but also just better statewide data helps us understand what's going on in the facilities.
Tad Weiser, live in Ypsi Township and part of the We Rock organization. And just a bigger picture question, this is all really great to hear all these details of things I never really knew about and the potential reforms here. And we're so much over the last number of years in the habit of needing to think in terms of scarcity and austerity, and we can only afford half of this or part of that. And this seems like, investing what we need to do so that things actually work. How big an increase in funding generally does this, compared to what we do now? I'm guessing it's not all that huge. We just have never tried to bite that off. But does that make sense?
Mm-hmm. Gosh.
I don't have a number.
Yeah.
Is it like double what we do now, or just?
I mean, it
10%
like,
more,
because our system is decentralized, right? Different counties are at different places, like previous reforms, like raising the age of juvenile court jurisdiction, for example, from 17 to 18. There were courts who were more ready for that change, even with like a 2-year implementation date than other counties were. There are counties that have community-based programs that already serve kids, already evidence-based programs are utilizing, that with increased funding they can expand and just serve more kids. There's other communities who simply need to establish those programs. Remember what I said about the Child Care Fund being a reimbursement model. There are, particularly in rural counties, often a need for that seed money to even launch the program in the first place. So you're going to need dollars for that for sure, and also to beyond the things that'll happen at the state level, like the scale division and all of that will need funding too. There'll also be funding needs for implementing new risk screening tools for those who don't utilize them. But again, there's some that do, there's some that don't, and it varies across the state. So it's hard to give a number, and a complete number.
Pay for it and do it.
Yeah.
Thank you.
Hi, Kim. Hi, Jason. Heather Martin, founding director of Youth Arts Alliance, an organization that provides healing-centered, i.e. trauma-informed arts programming to young people, both in the carceral system and in community, for the last decade. And YAA has been in many of the counties across the state. We know well the disparity between counties. Different than the system at large. We have a tremendous amount of data showing the impact of trauma-informed, evidence-based arts programming for young people. I happily share that with all of the counties where we operate, and it may be some of the only data that's available, which is interesting. I'm just going to pause. And then in thinking about particularly this child care fund reallocation for community investment, the reimbursement rate at 75%, this is a huge shift. This is a big deal. I'm like so nervous, even though you all look so nice. I'm gonna set my book down so I don't just shake. Okay, it's gonna be fine. It's not a big deal. We're all people.
It's not a big deal.
It's not a big deal. So Youth Arts Alliance worked for our entire history. Anyone coming into programming doesn't pay, right? Any young person, any family. And the way that we do that is we leverage child care fund dollars towards the cost of our programming, ensuring that anyone participating isn't paying, right? This is where it gets tricky, because not one family, not one young person that I've met in 15 years of doing this work didn't need something long before they hit the door of the facility, long before they hit the door of the community center for the extra resource, wherever it may be, right? And so the problem is that child care fund money is tied up, is wound tight, right? You get child care fund dollars once you're incarcerated, right? Those are eligible resources for you upon coming into residential facility. DHHS distributes child care fund money towards young people who have been involved in abuse neglect docket, foster care docket, who meet certain eligibility, right, criteria. And so what happens when the child care fund tightens the red tape around each one of these categories? Have you been in a situation where there's suspected abuse, neglect in your home? Is it substantiated? Then you're eligible to receive these resources. But the truth is, and what I want to hear from you around this child care fund flexibility, this increase on diversion and hopefully deflection of investment for young people who needed the resource long before it ever arrived, because they didn't trigger the financial investment from the state, from the county, until it got really bad.
Yeah.
And so as an organization that has impact data, every time in the reports, like alternative community resources or services, it's like Youth Arts Alliance, a myriad of other beautiful organizations actually adhering to standards and best practices with more fidelity than the system at large, arguably. What can we expect around this 75% reimbursement, and who will be delegating or creating eligibility around those dollars? Because there's a lot of community-based organizations doing good work, eager to engage, sweeping through funding resources, private grants, foundational dollars, state dollars, county dollars, and I think that these organizations need to be at the table for eligibility, because our outcomes could be better demonstrated than the system at large, are more impactful, and families and young people have been asking for them for years. Most of these disappointments in this report, as folks who have been in the field, we all know them and have known them, and the numbers aren't changing, right? I am so encouraged by these recommendations. This is really incredible work, and I think this fundamental funding issue is one that we should really talk about in specificity, because it is how we explain to families why they had to fall so far before anything was offered. So, thank you. Yeah, I don't know.
Yeah, no, thank you, Heather. So the way that, at least for community-based care, the child care fund works is that the two entities that can be reimbursed for child care fund services are local DHHS offices, like Heather mentioned, and the courts. For delinquency cases, for JJ, youth services aren't eligible for child care fund services until a petition's been filed with the juvenile court. And so even diversion, once you're just diverting them right back out, to be eligible for that reimbursement, those reimbursement dollars for diversion, a kid their case has to at least make it to the court or the prosecutor's office before they're eligible for it. There's also some rules, and again, like I tried to only highlight high-level things within each recommendation, but one of the sub-recommendations or points related to that child care fund change is changing even what diversion looks like at 2 points. So right now, in community-based care, the language around community-based care for the child care fund reimbursement requires that local jurisdictions treat a young person intensively. So that means weekly face-to-face contacts. Like, the assumption is that you are putting in the work and the level of services needed to prevent a child from being placed out of the home, which is a good thing unless it's diversion, right? Like, these are supposed to be kids who theoretically would have a light touch. Sure, they could be referred to services, but essentially we're saying that this is their opportunity to address your needs without court involvement. And then if there's additional things, then we can revisit that. But having it be intensive makes it in some situations look really similar to probation and length of time and some of the things that they have to do to complete and get off of the diversion program. So that one of the changes is to look at that language to reduce, for example, face-to-face time, the length of stay, et cetera, for diversion. But then also the thing that didn't include in the slide, but really excited about, is that the recommendation is for the child care fund to support pre-arrest diversion. So before a petition's filed with the court. Now, I'm sure there's going to be lots of debate and negotiation, like what that means and what the criteria is for that. But I again, to the point of how you all can help, like, this is the opportunity for those groups that are funded by the child care fund to speak to legislators. One, help them understand what it is. You'd be surprised how many legislators don't know what the child care fund is or does, how it supports your work, and how you're able to help kids from it. But then also this piece around being able to support programming and services more upstream, making sure that they get that part right, because I think we have like a really good opportunity to support great prevention and diversion programs. Just like this discussion, there'll always be a cutoff point or a point where it's going to be these kids and then stop at this point. But we have an opportunity to really shape what pre-arrest diversion looks like in the state.
Okay.
Hope that answers your question, Heather.
3 more questions, okay?
Hi. First of all, I just want to thank both of you guys for standing in the gap for our young people in Michigan. But also, I want to thank everybody that's in here that's have a mission to help our young people that's in Michigan. My name is Deshaun Leaf. I'm the executive director of Underdog Nation. My whole goal is to help kids not go into the system. I am a juvenile justice impactor for youth. I got in the system when I was 11. I didn't get out of the system until I was 28. I'm 28 right now. But my whole goal for my nonprofit is to not allow these kids to make the decision to get into the system, because I know how hard it is to get out the system. Right now, thank you for you guys. I'm actually a part of a national campaign called Debt Free Justice Fellowship, if you heard of it, to be
congratulations.
an advocate, one of the 6 candidates to go nationally to advocate for our young people to get fines, fees, and restitution abolished in our state. But my question is, I'm not into politics. I just got off my bunk about 2 years ago. But the question is, why is it taking so long to make these, like, if y'all have the data and stuff that show the programs that is going to be effective, why is it taking so long to get these things abolished that's stopping our youth from being successful at an early age?
Thank you, and thank you. I'd love to talk to you too after this. But I mean, I think there's several reasons for the delay. One, I want to highlight that there has been some changes made, like raise the age and the record confidentiality stuff, but not enough. And simply the issue that Sometimes justice issues and justice reform isn't prioritized in the legislature. And then on top of that, youth justice isn't often thought about. That's why it was such a big deal for the governor to establish a task force solely looking at this population and the needs of the kids who come in contact with it. So I think it's that and just lack of prioritization. And we're forever in campaign season, in election season and stuff. You know? So that's the biggest impact.
And I want to shout out to Jason and his organization for really putting some of the foundations in place, and some other organizations that are supportive here in, you know, doing the reports, doing the assessment, drawing the light on it, such that the governor, you know, finally took this step. And so there was a lot of work done to get us where we are.
Good evening, all. My name is Leah Mills. I will be brief. In your presentation, you addressed the disproportionality of African-American youth being in the juvenile justice system. But when I looked through the report that was given, I didn't see anything that was solely focused on this particular racial demographic. I used to work in a high-secure facility, and when I was there, my population was 99.9% young black men. And so I wanted to know from you all, because I see the tribal, right, work group that's solely specific for them, is there a reason or rationale as to why the representation solely for this particular racial demographic is not addressed? And if not, is it just simply because we figure that the entire system solely focuses on the African-American population, and thus it does not need to be named? But my concern is that there is a lack, when I'm looking at the work groups and the names that are present, and not to just, you know, say that I'm being biased or looking at a name and saying, yes, this may not be a person of color, but I'm concerned about the representation that's at the table or the lack thereof. So I wanted to hear from you all, to hear what the rationale is as to why there's nothing focused on this population, which is the mass majority of the juvenile justice system. Why is there a lack of representation?
And things like that. I can
Yeah, so part of the answer about why there's attention to tribes is that there's a different court system that tribal kids go through, and a different set of judges and a different set of laws that apply to them. And so that was one reason that there was particular attention to that population, because those kids are often not in what we think of as the juvenile justice system. And so that's 10% of your answer.
But yeah, they had to ensure that whatever recommendations came up with aligned with tribal sovereignty was the main issue for that. But I would say for black youth in the system and not specifically addressing racial disparities, it definitely was a charge of the task force. It was included in the executive order establishing, not necessarily specifically for black youth, but really identifying and addressing racial disparities. One of the issues is it is simply data, you know, not having enough data about what kind of offenses kids commit, where they end up. Like that really places a hindrance on being targeted and having targeted conversations about who's in the system, specifically black youth, but you can make the same case about girls, you know, LGBTQ youth, and across the board for subpopulations. But it was something that I stress, along with other advocates, that if you ignore that, and it's hard to, I would say, for and I don't want to place blame on anybody, but you know, you have in a multi-stakeholder task force like that, people from communities for whom racial disparities isn't an issue, and may not necessarily be top line priority for them. So it takes the people who are extremely passionate about that issue to make sure that it's front and center.
So can I follow up on that, and I won't belabor the point. My concern is when I look at the report and I'm looking at the names of individuals that's on here and where they are from, my concern is that the black voice is not at the table, right? The cultural insight and awareness is not So when you all are making, right, these legislative rulings, it does not have the informed voice. So that's what I was addressing, not so much so about the tribal laws, but just kind of looking at the disparities, even in this document, that will continue to perpetuate why we're here.
I agree with that, and I think that it's important that these conversations continue outside of the task force. We didn't appoint the people on it, but I want to say though, the child welfare system, for example, has tons of discussions around permanency and issues related to child welfare and abuse and neglect. But they also were intentional in creating a task force specifically looking at racial disparities and the impact of black and brown youth, I believe, but in the system. And I think that for juvenile justice, it's going to require that too. And then the table will look different, because those who may say, this isn't the issue for me in my district or my county, they want to participate, but in those who extremely are passionate will, Definitely, there were differences in experience, even in the task force, between people who, and there were some, who came from urban areas or majority black areas versus those who don't. But to have an intentional conversation about it, for example, people have to set that table. I think that is ultimately the answer to that. Thank you for that question.
Two more quick questions. I'll let her go first. Oh,
Thank you. My name is Shirley Beckley, and I'm a longtime resident here in Ann Arbor. And as a mother and a grandmother, I'm just wondering, is this task force going to do anything, or is it doing anything about how our children get in the juvenile justice system? I have had children and grandchildren put in the system for being out after curfew, which is 10 o'clock if you're 17 or you're under. And that starts the ball rolling. So I'm wondering if this task force, now I've been told to hurry up, but I'm gonna take my time. I think this is important enough to take some time about. It's our children we talk about. Is this justice task force and our representatives doing anything about how they get into this system and how we need to eliminate, especially the curfew, which is kind of, I've been told that Ann Arbor has eliminated it, but Ypsi still has it, but the state has it, so they can charge them under the state law. So are we doing anything about that so that they don't even get in the system over something as frivolous as that? Thank you.
I think that the task force wasn't charged with and didn't address some things that lead kids to interact with the youth system. So it doesn't address policing. It doesn't address police officers in our schools. It doesn't address a host of other things that happen to young people before they hit the courthouse door. And that is not in the recommendations, and it's not in the data we got. And so that it is left unaddressed. Where the task force might impact some of the issues that you're talking about are with respect to the question around diversion. So if that child gets arrested for a curfew, then what happens, right? We can make decisions about whether to charge and put that person engaged in a formal court system, or we can make decisions that that person doesn't belong in a formal court system, and that's an inappropriate place for them. And so that's an important diversion question that the task force is addressing and is really critical to the kind of low-risk kids that you're talking about that don't belong court involved.
So we'll take one more question, and then we'll be dispersing.
Hi, I'm Perry. I'm the Executive Director of the Student Advocacy Center of Michigan, also one of the child care fund provider in Wayne County and Washtenaw. And we've spent a lot of time working with court-involved youth, and Jason, you know, I've talked a lot about that. Sorry, I kind of have two questions, so skip it one if you want. But to Heather's point about where that line is drawn to who is eligible for services, so important. Spent more than 20 years in Washtenaw County with families begging, how do I access this service or that service? And that's been pretty heart-wrenching in that time. But in Wayne County, they do have a system, Jason, as you know, where you can fill out an at-risk petition, and you click things like expulsion or truancy, right? So I just think about how many more kids we could catch in Washtenaw County. Of course, you have to have a lot more funding for that. And so I just wonder if you have thoughts, if we can bring the conversation to our own community here in Washtenaw, like why is that happening there and not here? And like how could it, if you have advice on that, especially with some of the people in this room, would love to hear that, I'm sure. And then just any thoughts, or can you tell us about conversations about how it will be incentivized to make the system more trauma responsive and trauma informed throughout? And I'm sure many of us could tell stories just about all the layers of, I mean, everything about if anyone's spent time in the juvenile detention facility, every moment of that is trauma, right? And so what are we, I don't know if that's part of the conversation, but if it was, I'd love to hear a little bit about that. Thanks.
I'll do the child care fund one. I mean, like I said earlier around the, and thanks, Perry, around the child care fund and all of these recommendations is that, you know, these recommendations are out in the universe now, you know. The task force is essentially done with their work and disbanded. And now these recommendations are amongst the people who have to do the work to implement them. I think that the child care fund conversation, specifically around pre-arrest diversion, is ripe for community members to engage with their legislators, those who control the budget, but also who are going to move these individual bill items to ensure that it meets what they want. You know, this is the opportunity for us, folks who are interested in treatment-focused reform and a justice system that isn't overutilized, over-relied upon, that's evidence-based, trauma-informed, culturally competent, all those things. Like, this is the opportunity for us to speak to those wants, to those needs. And so I would just, again, if you're a service provider especially, receiving child care fund dollars, this is your opportunity to you know, take action and ensure that whatever reforms come from this isn't, you know, limited to the same old, not that there aren't some great historical, you know, long-term service providers, but that, you know, we're really thinking outside of the box and innovative about how this funding can be used to the maximum impact. There are other states that have made similar changes, like this CCF change to 75%. Illinois, Ohio, they had similar models like that, and they saw dramatic decreases in the use of detention and out-of-home placement because of it. 2 programs in the community that can serve 10 kids for the price of 1. But it's making that argument to the state and the powers that be that's important.
I think we're wrapping up. Yeah. No. I'm happy to stay after and talk with people, but.
Thanking our presenters. Thank you. And both Kimberly and Jason said they would remain if you wanted to talk with them further. And